Okay. Good evening, everyone. Look at that. Clearly from the noise level, this party has started. Good evening, and a warm welcome to our alumni, donor, and special guests. My name is Fred Lee. I am the Senior Director of Alumni Engagement at Alumni UBC, and it is my great pleasure on behalf of the Peter Allard School of Law and Alumni UBC to thank all of you for joining us here in person and to all of our guests watching online. Hello. I am very excited to be here tonight for this very special event, Protecting Free Tweets, Taking Back Freedom of Expression in Canada's Town Square. It is also my pleasure to introduce and welcome a dear friend, our moderator for this evening, Peg Fong. Peg is the Vancouver correspondent for The Economist magazine and was a staff newspaper reporter at the Vancouver Sun, the Globe and Mail, and the Toronto Star. She was a television and radio reporter for the CBC. She teaches media ethics and the fundamentals of reporting at Langara College and is a sessional instructor at the Sauder School of Business at UBC. In 2020, she created and hosted the international podcast Alone Together, a curious exploration of loneliness where she interviewed more than 150 experts around the world. Her book, based on that podcast, will be published in March 2024 by Orca Books, and I look forward to its release. Everyone, please join me in welcoming our moderator, Peg Fong.
Thank you so much for that warm welcome, Fred, and thank you to all of you for joining us for this evening's event, Protecting Free Tweets, Taking Back Freedom of Expression in Canada's Town Square. I would like to begin by acknowledging that we are gathered on the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and the Tsleil-Waututh peoples. And as a journalism instructor from Langara College, I also bring acknowledgement and greetings from Snowe Lalem, which means the House of Teaching. It was a name given to our institution by the Musqueam people. I would like to say that this has been an event that I've been really looking forward to because there is so much that we want to unwrap here on this conversation. As a journalist and as an educator, I have a strong vested interest in the issues that led Joel to file his lawsuit. And I know many of you have questions, as I do, and Professor Kong as well. As you were advised in your event reminder email, we will be using Slido tonight to manage questions. So if you haven't registered now, it is www.slido.com and enter the event code of free tweets. The hashtag is already there. So using Slido, you will be able to both ask questions and upvote other questions. Now, please allow me to introduce our guests. Professor Joel Bakan is an author, filmmaker, and a professor of law at the University of British Columbia. His work examines the social, economic, and political dimensions of law, and he has published in leading legal and social science journals, as well as in the popular press. Professor Bakan has won numerous awards for his scholarship and his teaching, worked on landmark legal cases, and perhaps another landmark legal case, and government policy. He has served frequently as a media commentator. Professor Hoy Kong is the inaugural holder of the Right Honorable Beverly McLaughlin, PC, UBC Professorship in Constitutional Law, which he assumed in 2018. He is a senior research fellow at the University of Texas at Austin's program on constitutional studies and was a Peter Wall Scholar from 2020 to 2021. He researches and teaches in the areas of constitutional, administrative, municipal, and comparative law, and constitutional and public law theory. I would like to start off this conversation, if you don't mind, quoting journalist A.J. Liebling, who once said, "Freedom of the press is guaranteed only for those who own one." At that time that he said this, in 1960, The press was pretty straightforward. There were newspapers, there were magazines, radio was in decline, and television news and television was in its infancy. You could be a twit at that time, but no one knew what being on Twitter meant. So A.J. Liebling also said, the function of the press in society is to inform, but its role in society is to make money. So we need the media, and social media, of course, is included in that, in order for citizens to communicate with public institutions and public institutions to communicate with us, the voters, the watchdogs. And of course, we need the media to be able to communicate with each other. So can we start there, Joel? What is the role of Twitter in the town square of free speech? Perhaps you can give us a quick overview and the nature of your case against Twitter.
Sure. Well, thank you very much, Bakan. With a hand for Peg. Fred and Jennifer and Hoy and all the people doing the technical work and everybody who helped organize this and all of you for coming. I really am grateful. I always enjoy talking about this case. And it began, well, so here's the story. I mean, back in the early 2000s, I wrote a book and was the writer of a documentary film based on a book called The Corporation, which some of you may have seen or heard about. And over the years between 2003, when it was released, and around 2013, 10 years later, I realized that something was happening in the world of corporations. And in particular, I realized that all the criticism that we had done in that film hadn't made any difference. I mean, the film was really a failure by that standard. It didn't really change anything. And if anything, things were getting worse. Climate change, social inequality, labor rights, colonialism, all of it was getting worse, and corporations were getting bigger and more powerful. And so, I thought around 2013, 14, I thought it was time for a sequel, started thinking about it. And in 2020, the sequel was released. The film was called The New Corporation, the unfortunately necessary sequel, unfortunately necessary for all the reasons that it's provided. And it was based on a book called The New Corporation. The subtitle was How Good Corporations Are Bad for Democracy. I don't want to get into the arguments about that I make in those books. Suffice it to say, they're critical of corporate capitalism. They champion democracy, and in particular social democracy, as a counter to the power of capital and corporations. So it's a distinctively left-wing kind of argument, but not a very radical one. A fairly left of center argument, kind of NDP-ish, would be the best way to put it. So not sort of really radical, as I say. And you know, the new film was successful. The book was. It won awards and things like that. And you know, it screened and continues to screen. Not that I'm putting in a plug or anything, but you can watch it on Crave if you wish, and on all the major platforms, with the names of which, this is the irony of all things, Google, Apple, all the big corporations that we criticize are carrying the film. So, so all of that happened. In 2020, around 2020, the producers of the film, I was a director along with Jennifer Abbott and the writer of the film. The producers of the film decided they wanted to run a publicity campaign. They turned to Kat Dodds and her company Cool World, and Kat is here tonight, right there, to do the publicity, to do some of it, because Kat had done the publicity for the first film and had done a fantastic job. So Kat and her company decided they were going to mount a Twitter campaign. Now, the thing about Twitter is if you simply tweet something and you have 1,000 followers or 2,000 followers or even 10,000 followers, it doesn't have much impact. It only goes to a small percentage of your followers, and it doesn't go to any of your non-followers. So to have any kind of impact when you're doing something like publicizing a film, you need to do what's called a promoted tweet. That's what it was called at the time. Now it's called a promoted ad. It's a very simple idea. You make a few clicks within a regular tweet and you determine how much you're prepared to pay, what kind of audiences you want to target. And the more you're prepared to pay, the more people will see your tweet and the more fine-tuned you can make the targeting. This is a particularly important thing for a film like mine because we don't have a big studio behind us. We're a small independent company that's making the film. And so Twitter is actually a really good place to go, especially for a social issues documentary, because the people who congregate on Twitter are social issues kind of people. Twitter is distinct from other platforms in the extent to which social, political, policy kinds of debates and information happen. So that's why Twitter was important. So we say, Kat and her company go to promote the tweet, and Twitter says, no, you can't promote that tweet. Its algorithms catch the tweet. As soon as we do it, they come back and they say, no, it violates our policies. So Kat and her company ask why? And it comes back, it violates our sensitive targeting policy. So Cool World says, why? It doesn't do this, it doesn't do that. Those are the things prohibited by your policy. So they come back with a third rejection and they say, it violates our inappropriate content policy. So they write back, why does it do that? On and on. And what comes back is it violates our political content policy. So within 4 responses, 4 rejections for 3 different reasons. And so finally, Cool World says, can we talk to a human being? Like, we're getting all of these responses from basically bots, artificial intelligence. And so a human being emerges and the human being says, we agree, the human being agrees with the bots, that the bots are right, this thing violates all of those policies. And so we write back again and we say, why, et cetera. They say, nope, that's it, we're done. So we did what is often referred to in law as we had exhausted our local remedies, and we were exhausted by it, I have to say. So, we'd gone through their internal procedures, and so I got together with a friend of mine. He used to teach at the University of Toronto Law School. He went on to become dean of the law school at Berkeley, Sujit Chowdhury, and now he's, I would say, I'm biased, he's a friend, Canada's leading constitutional lawyer, putting aside present company. And so anyways, he thought this was interesting. Kat was the plaintiff, is the plaintiff in the case, and we decided we would file an application in the Ontario Superior Court. And so that is what we did. Twitter responded by with an application, a motion to strike our claim. We went, we argued, we fought their motion, and we won. And the judge, and you can go to Canley and look up Cool World versus Twitter and find the judgment. The judge said that Justice Fred Myers, said that he thought there was a plausible case here. It wasn't the case that there was no reasonable cause of action, and that the causes of action the reasonable cause of action that we were arguing lay in contract law, understood through the lens of the Charter's guarantee of freedom of expression. So the argument was an argument about how certain doctrines in contract law, in particular public policy, unconscionability, sort of have synergy with a line of cases that the Supreme Court has come down with, saying that charter values are relevant in private litigation. We put those 2 things together, we made our arguments, and we'll talk more about those arguments. But for now, I just wanted to kind of give the lay of the land of how we got here. Oh, and by the way, so we won the motion to strike, and we're now in the process of sort of gearing up for a full trial. We've changed the process from an application to an action, which will allow cross-examination and all of that. And so that's where we're moving, depending on what Twitter's lawyers decide to do in response to that. But one way or another, application or action will be proceeding in the Ontario Superior Court on the merits of this case.
So great. Did you want to show the actual what you were trying to get advertised?
Yeah, I guess for the purpose of, I think it'd be interesting for us all to look at what Twitter found to violate all of its policies. And I'm sorry, I have to say one more thing. There are the policies, but the case is really targeting Twitter's underlying discretion to ban any user or any content it wishes. I have to read this to you because you might not believe it if you didn't, but if I didn't, but basically the contract, clause 4 of the contract, and this is what we're really challenging, is we may suspend or terminate your account or cease providing you with all or part of the services at any time for any, and this part I love, for any or no reason. So they have 100% unfettered, absolute discretion. They could turf Justin Trudeau, the leader of the opposition, the Supreme Court of Canada, Leaf, Canada's or BC's public health officer. They can do anything they want within the realm of their contract, and that's what we are challenging. What they do is they often justify their restrictions through policies like the ones I mentioned, political content, et cetera. But they make it very clear in clause 4 that they don't have to. Their discretion is absolute. If they want, they can follow their policies, but they don't have to. So anyways, what you're going to see now is what was tweeted and what got us into trouble. The tweet that Cool World sent out was really nothing more than, hey, this film has been released. Here's a trailer. There was a link. If you clicked on the link, this is what you would see. This is what Twitter really didn't like. I think we need sound.
The greed economy is killing us.
We are so steeped in this commodification that it's hard to distinguish between being a consumer and being a citizen.
Seeing the documentary The Corporation, it opened my eyes.
Calling corporations psychopaths absolutely has an impact.
Can we take the resources of corporations and get them to focus on the needs of the poor?
There is no such thing as corporate social responsibility.
They literally play the scene with life on Earth.
The changes that we fear are coming faster than anybody thought.
It's completely out of control. Corporations have figured out there are really big business opportunities in these public sectors.
Private schools for the poor is a $51 billion a year market.
Take the education system, take the healthcare system.
That's a direct threat to democracy.
Their reach cannot be underestimated. They know everything about us.
If we don't push back, we're going to live in a world in which they are governing us privately for the profit motive.
One of the largest corporate bailouts with as few strings as possible in American history. Shameful.
Global pandemic. What do we do now? Let's do a tax cut.
The pandemic revealed that we need to contain corporate power.
The democracy is trying to breathe. We can't breathe because of the weight of poverty in our midst.
We have not come here to beg your leaders to care. Change is coming, whether you like it or not.
Are you actually going to challenge the power of corporations? This is what the 2020s will be about.
You have to really ask yourself, what was your role in this moment in history?
So that's what Twitter felt violated their policy and what they barred from being promoted on their platform. And that was before Elon Musk took over.
So I thought maybe we could start the conversation on a somewhat nerdy note.
Hey, look who's up here.
So one of the speakers on the ad said, look, corporations govern us privately through the profit motive. Yeah? And so Twitter's a private actor, but you're bringing charter arguments, and charter arguments apply to the state. So could you just sort of flesh out why you're raising a charter claim in the context of a private corporation?
He actually knows the answer to this question, but
I'm just trying to make him look good.
yeah. So this is what Twitter's counsel argued, and unsuccessfully in the motion to strike. They said, look, read section 32. It says the charter applies to government, to the legislatures of the province, and to parliament. It doesn't apply to a corporation that is a private entity. So, there's no case here. And what we argued was, it's actually not section 32 that's relevant here. It's section 52. Section 52 is in the Constitution Act. It's not in the charter. So it applies to the Constitution Act of 1982. So it applies to the entire Constitution. And what it says is that any law that is inconsistent with the Constitution, with a constitutional provision, is of no force or effect to the extent of the inconsistency. And so that was the basis of our argument, because in the Dolphin Delivery case, which made it very clear that under section 32, the charter does not apply in private litigation, Justice McIntyre said that under section 52, the charter does apply to the common law, because section 52 says any law. And so he said that. But he said the problem here is that the way the case is framed in Dolphin Delivery, and I'm assuming most of you know what Dolphin Delivery is, but the way the case is framed in Dolphin Delivery, basically you're saying that the judiciary is government and it isn't. And so we can't do this. So then in another case, PepsiCo and the Retail Wholesale Department Store Union, which came about maybe 10 or 15 years after the Dolphin Delivery case, and just full disclosure, I wrote the factum in that case for the union. But what we realized, myself and John Bajan, who was arguing the case for the Supreme Court of Canada, what we realized was that he, who was representing the same union in Dolphin Delivery, had made a huge mistake. He had gone after the injunction that the court had issued and said it violated the charter. What he should have gone after was the common law restrictions on secondary picketing. So in the PepsiCo case, that's what we went after. We said that those common law restrictions, are basically contradictory to the charter value of freedom of expression. And the union won in that case. And so Dolphin Delivery was effectively flipped in terms of the result. But it was due to this very different strategy of picking up on the idea that the common law is subject to the charter, even though none of the triangle of entities in a private litigation, the court and the two private parties, none of them are subject to the charter, but the common law is. So in a case that happened between Dolphin Delivery and the PepsiCo case called Hill and the Church of Scientology, the court said, you know what? Justice McIntyre said that the common law is subject to the charter, and it's true, because section 52 says that any law that's inconsistent. So how are we going to square this circle? That section 32 says the charter only applies to government entities, and section 52 says it applies to the common law, which governs private litigation. How do we deal with that? And so what the court said is, well, here's how we're going to deal with it. We're going to say that there are no charter rights involved in a private litigation case. Why? Because there's no government entity to have duties corresponding to those rights. So there can't be rights because there's no entity to carry the duty. So there's no rights. But what there are, the court said in Hill and Church Scientology, there are charter values. And the charter value at issue in that case, because it was a defamation case, was freedom of expression. And so what we have to do to give effect to section 52 while respecting the limits of section 32 is come up with a kind of methodology for dealing with these situations where people raise charter values in private litigation. And this is the methodology, the court said. We're going to balance the competing values. We're going to say, what's the value that underlies defamation law, protection of reputation, et cetera, and what's the value that underlies challenges to defamation law, freedom of expression. And we're going to weigh those values and see which one comes out more weighty. In that case, it was the value of defamation law, reputation protection, that was more weighty than the freedom of expression interest, according to the court. In the PepsiCo case that I mentioned, it was the value of freedom of expression of the union that the court found more weighty than the corresponding protection of parties from secondary picketing. So it's a bit subjective, it's a bit uncertain, but that is what we've got. And there have been 6 or 7 major cases where the Supreme Court has activated charter values in the context of private litigation. And in the Ontario Court of Appeal, Justice Robert Sharp, in a case called Jones, actually took things a step further and said that because of charter values, you could create an actual new cause of action in tort. There was no cause of action for invasion of privacy in tort. And what Justice Sharp said in the Ontario Court of Appeal was that because privacy is kind of derived from charter kinds of values, you can fashion out of that an entirely new cause of action. So we're taking this approach to contract law. And what we're saying in this case is basically that the doctrine of public policy in contract law has to be understood in relation to charter values, or to put it in clearer terms, when a contracting party uses their contract power to override important charter values, that is a breach of the doctrine of public policy in contract law. That's one of our arguments. The second argument is that when a contract entirely deprives one of the parties of any freedom of speech interest, and it does so in a contract of adhesion with serious inequality of bargaining power and all of that, that is unconscionable. And so those are our 2 basic arguments that blend contract law doctrines with charter values. And I'm fortunate to teach both contract law and charters. So this blending was fairly natural. It is a novel case, but it's a novel case that's very substantially grounded in some very well entrenched and defined jurisprudence of the Supreme Court of Canada, and which is why Justice Myers found that there was a plausible cause of action there.
So you want to talk a little bit about the novelty of the case? So in the line of cases you're talking about, right, often what you have is a right under private law balanced against a charter right. But one line of your argument is that the corporation itself is asserting a constitutional right, against under freedom of expression around compelled speech, right? And so what we have here is a balance of an asserted constitutional right on the part of, not right, but a constitutional value on the part of the corporation balanced against the constitutional interest on the part of, you, right? So that's slightly different than where the cases have taken us so far, right? And there's other novelties, but let's just start with that one. That seems to me to be pushing the cases a little bit farther than they have previously gone.
Yeah. I mean, I guess the first thing I would say in response to that is to push back against the idea that none of the cases so far have raised issues that have rooting in the Constitution. In Hill itself, the court says that protection of reputation engages charter values of Section 7 and so forth. But having said that, I mean, there's no question in this case that Twitter has a freedom of expression interest, absolutely. And Twitter has a freedom of contract interest. So it has both of those interests. And so the question that the court's going to have to address when it gets to the merits of this case is, does the freedom of expression interest that we have in relation to this film and it being shut down and all of that, How does that stack up against the freedom of expression interest that Twitter has and the freedom of contract interest that Twitter has? Well, in terms of the freedom of contract interest, the court has already told us in a number of leading contract cases, I'm thinking of Uber, of Bazian, for those of you who follow these things, Waste Tech, in a whole bunch of relatively recent Supreme Court of Canada cases, the court has told us that freedom of contract is never an absolute value. I mean, the whole presumption of the doctrine of unconscionability in public policy is that there will be times when we have to basically not enforce freedom of contract, where there are other values that outweigh freedom of contract. So we're not really doing anything very radical here. All we're saying is that sometimes those values that outweigh freedom of contract may be charter values. And so there's nothing sort of novel in that. In terms of the other piece, the freedom of expression interest that Twitter has, a really important part of our case is that we limit the degree to which we're asking the court to interfere with Twitter's discretion. What our argument is not that the court should have carte blanche in reviewing and monitoring the discretion that's exercised by Twitter as to what it can and can't and does and wants to and doesn't want to put on its platform. All we're saying is that when it interferes with speech that our Supreme Court of Canada has routinely said is of the highest value, namely, and this is how we define it, social and political speech that does not cause harm, which is what I think that trailer is. When it interferes with that, then it crosses a line. When it exercises its discretion to do that, then the judiciary should step in with doctrines like public policy or unconscionability or whatever. So we're saying Twitter does have a freedom of expression interest. We're cognizant of that, and we don't want to encroach upon it too substantially. But we do want to encroach upon it to the point that we feel is necessary in order to protect this very important, high-value type of free speech.
Yeah, so I think that the novelty of your argument on the Constitution, so you're right, in Hill they say, look, reputation is grounded in privacy, but it's a general constitutional right, constitutional value of privacy. I think what's novel about your argument is that you're working within the confines of freedom of expression doctrine, right? And so you have specific interests that are recognized by the Supreme Court under freedom of expression doctrine, right? And so I think it's the specificity of the constitutional argument and the constitutional claim on the part of Twitter, right? So I think, so Twitter, the interest probably would be something like the autonomy interest, right? The ability to express oneself. And that's very specific, and I think that's somewhat novel.
Yeah.
Maybe let's turn now to the unconscionability argument, because I think that's also kind of novel. So in standard, one part of your unconscionability argument is not novel, right? So the procedural unconstitutionality part of your argument is not novel. So the inequality of bargaining power, all of that stuff. It's the substantive unconscionability argument, right? The actual bargain itself.
Yeah, the improvidence.
The improvidence of the bargain itself. Now, typically in unconscionability cases, what demonstrates the improvidence of the bargain is a loss of economic interest. So if you think about Lloyd's Bank Bundy, right, or you think about Williams Walker in the United States, what triggers the unconscionability interest is an economic interest. What's novel about your argument is that that's not the focus of your unconscionability claim. Your focus of your unconscionability claim is the constitutional interest and the extent of the damage done there. Yeah. So maybe talk a little bit about that aspect of the novelty of your argument.
Yeah. I mean, I think let me begin, and I'm not dodging the question, but let me begin by speaking in more, I guess, general terms about the relationship between constitutional rights and contract law doctrines like unconscionability and like public policy. Part of what we're relying on is what might be called a global trend. And those of you who know the work of Ernest Weinrod, retired law professor at the University of Toronto, he just wrote a spectacular book about what is described as horizontality. And horizontality is a concept that says that constitutional and values and constitutional rights have relevance in relations between and among individuals. That's why it's called horizontal, rather than simply vertical relationships between the state and the individual. And this is a very substantial trend in comparative constitutional law. The case that we're arguing was successful before the Federal Court of Justice in Germany with respect to Facebook. So the very same kind of argument about the horizontal effects of constitutional rights in a private law case were used to push back against various restrictions that Facebook had imposed on users. Israeli courts, South African courts, many European courts, Japanese courts, have all sort of developed this notion of horizontality that says when you're looking at private law, you always have to have in the back of your mind, is there some way in which constitutional values become relevant and are engaged? That is a question you always have to ask. Now, in their own sort of way, our Supreme Court justices have basically developed a horizontality jurisprudence in the cases that we've been talking about. And this is a huge revolutionary movement that, as I say, many people, scholars, jurists, judges around the world have been calling for. And the basic argument, and Ernie Weinreb, develops this in an entire book, but the basic argument is there's something very arbitrary about the cutoff between public and private entities when we're talking about constitutive values. That's a constitution constitutes us. So that I guess, very American ideal of the state being the Leviathan and the only entity that needs shackling by a constitution seems a bit dated and seems a bit out of sync with a lot of what the rest of the world is doing. So moving into unconscionability, the question then that we ask is, okay, we have this doctrine of unconscionability. It says that when two things happen, a contractual clause shouldn't be enforced. When that contractual clause is come to between two highly unequal parties, when one party is weak and the other party is strong. The classic Supreme Court of Canada case is Uber, the big company, versus Mr. Heller, an Uber Eats driver. Classic case. And you're absolutely right, in that case, the interests were economic. But the second question that you have to ask is, okay, you've established the inequality of bargaining power. Now, is the deal that was rendered as a result of the coming together of these two parties improvident? Is it so unfair that it would be unconscionable to enforce it? There's nothing as a matter of principle that says that can only apply to economic interests. And our argument is that it is improvident, it is unfair when the power of the more powerful party is used to negate entirely the free speech interests of the weaker party. In our case, the weaker party being Kat and her company Cool World, which she operates out of her apartment in the east side of Vancouver. It's not a multinational by any stretch. It's sort of a one-person show. So that's our argument. And so the argument I would make is, yes, it's novel. And I haven't done enough of a search through unconscionability doctrines around the world to see if non-economic interests, and particularly constitutional interests, come into the mix in defining improvidence in these cases. But as a matter of principle, I think strongly that it's arguable. And again, Justice Myers thinks it's arguable as well. So yes, it's novel, but again, it's strongly grounded in well-entrenched principle.
So how are we doing for time? Are we at the point where we open things up to the, no, we're not. How many more minutes? 8 more minutes. Okay, great. So I agree with you. So I think you're right that it's novel and there's nothing. But I want to ask, sort of push a little bit on the idea that there's nothing in principle that stops the court from extending the doctrine the way that you're suggesting. So when you cite dolphin delivery, the specific paragraph that you're talking about, when they talk about the application of the charter, right? They make the Section 52 argument, but they also really lean heavily on the Section 32 argument. And they say the charter cannot apply when it's the common law as between two private actors. Yeah? Now, in cases where you're using charter values as a kind of balancing of interests, right? And not protecting the charter interest in and of itself, right? You don't engage that concern about two private actors and the charter rights themselves, right? The argument that you're pushing seems to put you exactly in that direction, right? Which would put you exactly against the dividing line between Section 32 and, right? So, and the whole line of, the whole hill line of cases, right?
Yeah. So this is, I mean, the unconscionability argument, I think, is in some ways a weaker argument than the public policy argument, partly for these reasons. Because in the public policy argument, what we're saying is, as a matter of what's good for the public, it is not good for Twitter to be able to restrict social and political speech that is harmless. So we're not talking about the rights of the individual, we're talking about the public interest in Twitter doing that. And we're basing that argument on two things. One is the nature of Twitter. And a substantial part of our argument, some of you may have heard of Taylor Owen, he's a communication theorist at McGill, and a very sort of great scholar on the issue of social media platforms and whatnot. And he's an expert, one of our expert witnesses. And the kinds of arguments we're making that he's going to testify to are that Twitter, though it's privately owned, operates as a town square or as a public arena, as a key part of Canada's democratic infrastructure. When Justin Trudeau wants to make an announcement, he does it on Twitter. When the Superior Court of Ontario wants to make a process announcement, they do it on Twitter. Public health authorities, they do it on Twitter. Twitter is unique among social media platforms in being a platform that governments use to engage with citizens and citizens with governments. That's the first part of our argument. The second part is, therefore, if Twitter has a right to ban anybody for any or no reason, including the Supreme Court of Canada, including Justin Trudeau, including my film, and anything that it wants without being accountable at all, that is a problem for public policy, given the role that Twitter plays as a public arena, de facto. So that's that argument. The unconscionability argument is potentially weaker because it's looking at the actual loss of the plaintiff. And therefore you say, you're talking about the plaintiff possessing something, and if they're possessing something, it must be a right, and Dolphin Delivery says no. So, given that I only have 5 minutes left, I can't go into a whole jurisprudential lecture about the nature of rights and interests and a German philosopher named Hofeld and all of this other stuff. Don't have time. But what I will say is this in response to the argument, that if you have something called a charter value, then it's totally plausible to have something called a charter interest that is not a charter right. And that is how we would frame what is possessed by the plaintiff in this case in the unconscionability argument. It's an interest in free speech, not a right to free speech, that she is giving up in this one-sided contract of adhesion.
So, and I think we have a couple of minutes left. So a lot of your argument turns on the unfettered nature of the discretion. Yeah. So if we were to take the sort of, if we had better policies in Twitter and they were more constrained, like that, wouldn't that change your analysis?
Yes.
Because I think part of your analysis is, like, it's the completely unfettered nature of the discretion which gives rise to the threat to the constitutional value, right? But if they were to constrain it, if the the policies that the bots were referring to in the first 3 rounds, right, were the actual policies,
Yeah.
wouldn't that change your argument?
Yeah, I mean, there's no question that if it was more constrained, then they wouldn't have caught our film. I mean, so we wouldn't even be here. It is definitely the absolute discretion that is absolutely abhorrent, given the role that Twitter plays in democratic life and democratic governance. If Twitter actually had decent policies, we would be in a different place for sure. And part of the remedy, I mean, in the German case, the remedy was effectively that the court wrote those provisions into the user agreement, Facebook's user agreement. It basically said, you have to give users rights to be informed that they're being restricted, what the reasons why they're being restricted, and allow them to make counter arguments and then have a genuine redecision process, redo the decision in a rational and objective way, says the court. And we, the courts, will maintain oversight over that process. That was the remedy, which is effectively what you're talking about. And in this case, I should just say the only remedy we're asking for, because we don't want to get into all that, is a declaration. We're asking the court for a declaration that this absolute discretion offends the doctrine of public policy and any remedy that this court sees to be fit and just. That's what we're asking for. And so we're not asking for a particular remedy, but you're absolutely right. That is the absolute discretion that Twitter has that caught our film. I mean, honestly, do you see anything in there that should be censored? You know, you're all gonna say, yeah, it was terrible. But anyways, and we can talk about that, but it was that absolute discretion that caught the film.
Okay, so we'll go to the questions then.
Thanks.
Thank you so much for that fascinating conversation. You know, maybe I'll start off by asking Hoy this question. How plausible is it that he might win?
Oh no, he's a total crackpot. I'm kidding. So I think on the balancing arguments so I think the unconscionability argument is the weaker one, right? Because if it reduces to basically making a charter claim, and so that's exactly what the whole line of cases from Hill onwards is trying to avoid, right? So I think that's the weaker argument. I think the balancing of the public policy versus the contractual rights argument, that's a stronger argument. And I think it seems to me plausible given that the court has recognized that kind of balancing across a range of cases. So I think that's the stronger argument. I think that's the one that's more likely, that's more consistent with the line of cases. And I don't think that like the move that you're making there. So I think the only sort of extension of the case law is to the extent that Twitter is making an actual specific kind of constitutional interest claim, that's an extension of what the courts typically talk about when they talk about, you know, the countervailing interest, right, which are typically framed very broadly. This is a very specific argument, but I don't think that's out of the realm of possibility. And I think that the arguments that you're making about the public square and all of the and the kind of specific harms to high value constitutional speech, I think those work really nicely in the balancing. So I think that's the stronger argument. I'm not 100% convinced by the unconscionability argument.
I feel like I'm on The Voice.
Yeah. Oh no, that's a solid B+.
I'd like to move to questions from the audience now. As a reminder for those of you both here in the room and at home, hello, Dr. Bakan, hi, Mom and Dad. Please use the Slido website, slido.com, with the event code freetweets to ask your questions and to upvote other questions. We have a number of, we've had many questions come in already. And if you are having difficulties and you're in this room and you really have a question you want to ask, please raise your hand and someone from the team will come around and help you out. So this had the most votes so far. Does Elon Musk's ownership of Twitter create a bigger audience who may want you to fail or succeed? What do you think, Joel?
Again, I feel like I'm on The Voice. Yeah, I mean, what I think is that the ownership of Elon Musk from a legal perspective doesn't really make a difference in the case. Twitter remains an entity that acted towards us in a certain way, and we're suing them. So to that extent, it doesn't make a difference. Where I think it does make a difference is some of our arguments about the arbitrary and discriminatory way that Twitter acted towards us, I think are even stronger now. With the company having gone private, there are certain checks and balances that no longer exist. And with Elon Musk taking the amount of control, albeit he just appointed a CEO, but my guess is he'll still be somewhat involved in running the platform. With Elon Musk taking the kind of control that he's taken, I think the risks that we talk about are even greater. And then I would add a third factor, and that is that the behavior of that person, Elon Musk, to this point would suggest that the risks are even greater. Knocking off 8 journalists not too long ago and then allowing them back on, deeming public broadcasters, labeling them as government owned. And then changing that, getting rid of the staff that's in charge of content monitoring in terms of hate literature and all that other kind of stuff. All of that suggests that the allowing a private operator to have as much influence as they have over core democratic discourse and debate is dangerous. It's more dangerous under Musk than it was before, is what I would say, simply because the potential for arbitrary and discriminatory action is greater.
Maybe I'll throw this question to Hoy. If this case is successful, do you expect it to have any other impacts on other social media platforms like TikTok, Meta, et cetera?
Yeah, so I think what's really, there's tons of interesting stuff about this case, but I think part of the question is, to the extent that your argument turns on the town square, right? You're gonna have to draw lines, right? So what is TikTok a town square of the same kind, right? Is Facebook. And so I think part of the challenge of the balancing that you're inviting the court into is an assessment of different platforms and the extent to which they have this kind of town square function. And I think that just raises a certain level of uncertainty in the law. So I think it's an open question, but I think the very openness of the question might be a reason why a court might not go down the line that you're pursuing, because it's going to be really difficult to line draw in the way that is sort of necessary for your analysis to get off the ground.
Yeah, and I would say in response to that, it's absolutely right. It didn't seem to intimidate Justice Myers, who characterized our argument correctly as being that Twitter is unique, at least in the current moment among social media platforms. And a large part of our argument and our expert testimony is that Twitter is unique. We actually go deep into questions of who uses Twitter, how do they use it. 97% of MPs have active Twitter accounts, and contrast it to Facebook and TikTok and the other platforms. And so we're very deliberate and clear in saying we think that line can be drawn. However, things can change. The Court of Justice in Germany in the Facebook case basically said that Facebook operates like a town square. So it does introduce uncertainty, but it's not the kind of uncertainty that I think can't be met with expert evidentiary records and a reasonable amount of judicial intelligence and discretion.
I think this goes well with our next question. Does Twitter's reach with how integral it's become to the dissemination of information have an impact on your argument? Will it also apply, or may it not apply, to smaller companies?
Yeah, and I think that's very similar to what we were talking about. Our argument is based on the idea that Twitter has become a de facto mechanism for governments in a very broad and substantial way, and public institutions, public utilities, courts to communicate with citizens, and for citizens to communicate with public institutions, and for journalists to source their information. I mean, mainstream non-social media journalism relies heavily, well, you would know this, of course, I mean, much more heavily on Twitter than on any of the other platforms. So I think it's the reach of Twitter and also the nature of Twitter as a place that you go for discussions on public policy and for government announcements and all that kind of stuff. That makes it unique in our argument. And I guess my argument would be, if we succeed and we win this case, it'll be up to somebody who gets censored by Facebook to go and make an argument that Facebook is analogous to Twitter. And it will be up to Facebook to say, we're not, which I think will be interesting for Facebook to say, no, we're not as important as Twitter to public life.
I have a question here. I just want to make sure I understand it correctly. How do you balance the defamation legal cases or crimes against the opinion versus fake news versus freedom of expression?
Yeah, and I think another thing that's really important in our case, I mean, let me just say for the record, I am a strong supporter of legislative, regulatory, and judicial restrictions on hate speech, on discriminatory speech, on dangerously misleading speech, on insurrectionist speech. I believe that there need to be public norms to govern social media platforms on that. And so we're very clear in our pleadings that we are talking about speech that the Supreme Court of Canada has identified as at the core of the freedom of speech guarantee, and that doesn't cause harm. And right away, that excludes misogynist speech, hate speech, all kinds of speech that in the Supreme Court of Canada's Section 2B and Section 1 jurisprudence, the court has said restrictions are justified on these kinds of speech because of the need to protect egalitarian and other values. So I believe in that, and I believe that our case is not one that would open up the whole domain to judges basically saying that Twitter is not allowed to restrict hate speech and so on and so forth, and misleading speech and fake news and all of that, where it's dangerous.
Hoy, do you think so? Do you think it could open it up?
I mean, I think, so on the Supreme Court of Canada's jurisprudence, probably not, right? But I mean, part of the thing is Twitter is a multinational corporation, and the free speech norms in somewhere like the United States are very different than from here. So does the sort of multinational character of Twitter affect your constitutional arguments at all?
I think not, because I don't think it affects regulatory arguments. It affects regulatory arguments to the extent that the effectiveness of regulation, whether it's judges making decisions or governments or legislatures, the effectiveness may be undermined by the multinational character of Twitter, but the legitimacy isn't. I mean, the point is Twitter operates here. It has to put its foot down in a jurisdiction, and that jurisdiction has certain norms that it has to enforce. And again, that's a problem that the German court confronted with Facebook, and it basically said, this is our ruling, this is our law, and when you're operating in Germany, you have to comply with it. Now, it may be, there may be technical problems in enforcing that compliance, but that is the law. And so I think it's really the same here.
Another question actually that works well with that is that someone asked about expanding on the town square aspect of this. We usually think of a town square as a public space. Is Twitter a public space?
No, not technically. Twitter is privately owned, and even more privately owned than it used to be, as it's been taken private. And we do not say that it is a publicly owned square. What we do say is that we're living in a different world. We open our factum by saying there's been a revolution in communications over the last 2 decades. And the world we're living in, to put it in a term, is that we have privatized our democratic debate and discourse by putting much of it onto privately owned platforms. The law has to deal with that. It can't just sort of bury its head in the sand and say, oh, well, those aren't public arenas, they're not publicly owned, so we're not going to deal with them. In a world where most of public discourse happens on privately owned domains, the law needs to deal with that. And what we've done is come up with a legal theory for how the law can deal with that. And we have preferred in our approach judicial regulation to government regulation. I mean, when you think about it, there are three potential regulators of speech on a social media platform. There's the private owner, there's government, and there's the judiciary. And if I were given a choice among those three, I would choose the judiciary to engage in this kind of regulation. The judiciary is expert on this. This is what they do in Section 2B cases. They deal with these values. And the judiciary isn't subject in the same way, and I know I'm idealizing this a bit, but it's not subject in the same way to the kinds of political extremes and currents that governments might be in playing a regulatory role and the specter of censorship. So it's all imperfect. Self-regulation by the company, regulation by government, legislation by legislatures, and judicial rulings. But of those options, my own view is that this approach of having judicial oversight through contract law is actually the best approach.
If the Canadian judiciary, and this is not a question, but my question, if the Canadian judiciary rules on this, what impact will it have on Twitter internationally?
Yeah, it's a great question. I mean, the answer is technically none, but in terms of how I would predict it'll play out, if this case is successful in Canada, there are very similar, I've mentioned already in Germany, a similar case has been successful at the highest court for civil and criminal matters. There are similar doctrines throughout the common law and the civil law world of public policy, of unconscionability. And so if this case is successful in Canada, I would imagine that other plaintiffs will come forward in other jurisdictions, including the United States. I think of most of the major countries where litigation might happen along these lines. It's probably least likely to succeed there, but the same doctrines exist there. The same doctrines of contract law exist there, unconscionability and public policy. And in US constitutional law, there's at least a history in cases like New York Times and Sullivan of courts bringing constitutional values into private cases.
Hoy, have any other similar lawsuits been filed that you're aware of?
Not that I'm aware, but I think that the private-public division in, for instance, the United States isn't as big as in Canada, right? So Shelley versus Kramer, New York Times versus, right? So I don't, to the extent that that's the key doctrinal obstacle in Canada, that doesn't exist in the United States, right? I mean, so, and just on the kind of novelty of the argument, I think that, courts have dealt with a similar kind of argument about privately owned public squares, right? So in a time when people actually did shopping in malls, right? That was a public square. So the Harrison and Carswell. So there's a line of cases that I think, so I don't think that this is a massive leap. I think that the courts have seen public squares in privately owned entities. So I don't think this is a difference in kind.
One of the more popular questions was, where can I read more about the background jurisprudence and the comparative laws in other countries? Mentioned the Germany case, for example.
Yeah, I mean, a really easy sort of start would be to read our factum, because we mention all of that comparative jurisprudence. And if you want to read the factum, you can go to www.thenewcorporation.movie, which is the website for the film. And when you go to the opening page, there's a red thing that says the Twitter case. Is that what it says? Yeah, the Twitter case. Just click on that, and then everything's there. And there are links to the judgment, to the original notice of application, to the factum and so on.
I'll ask this question first to you, Joel, and then I'll ask Hoy for the larger side of that. What are the ramifications if you lose?
Well, things will carry on the way that they are now. The fact is that there currently is no regulation of these platforms, either judicial or otherwise. We're providing a way, a legal model to create that kind of regulation to protect speech. And I would say there may be openings to protect people from speech as well through this kind of common law charter route. So things will carry on. The social media platforms will continue to have impunity to decide with absolute discretion what they will have on their platforms and what they won't. And while it may seem, even under Elon Musk and Facebook and everything else, while it may seem relatively benign at the moment, who knows where things go in this world when you provide absolute power to unaccountable entities.
Speaking about unfettered power, Hoy, what do you think social media? What does social media gain if this case is lost?
Well, I mean, I think it's more like what they don't lose. So they're not going to. So the courts aren't going to be the venue, at least on this line of argument. There may be other lines of argument. Yeah. But I don't know. I'm not as pessimistic as you are, in part because I'm not bringing this case. So I mean, I think that the arguments that you're making, and I mean, you're not making the remedial arguments, but if you were to make the remedial arguments about how to constrain the discretion in ways that would result in a better balancing, I'm not so pessimistic that a legislator couldn't pick that up.
Mm-hmm.
Yeah,
it could, but there seems to be a real reluctance. There's a real kind of political, pardon the word, constipation at the moment around regulating the platforms, and so that's part of my concern. But I agree with you. I mean, a legislature could do this. You could, and enact a fair social media contract terms act at the provincial level or probably at the federal level.
and I mean, just on that point, I think it aligns with the Bakan of the new corporation of the corporation and the Bakan of sort of critical legal studies. I think that Bakan, the earlier Bakan, would say that's exactly the route we should do. We should motivate people in the political sphere to engage in legislative change.
That Bakan is back in the past, in the sense that, I mean, what Hoy is talking about is I used to argue quite strongly in a book in 1997 that we should not rely on the courts to move us forward in a progressive way, and if anything, they were a regressive force. That was 1997. I think we're living in a very different political world now. We're living in a political world where increasingly extreme right-wing parties and groups are having considerable sway in forming governments or becoming influential forces in governmental systems. And governments have pulled back from really taking a robust regulatory approach to corporate capital. So I think in that world, there may be a place for the courts exactly in these kind of cases. I mean, look, the bottom line is, I made a film. I thought it was a pretty good film. I didn't think there was anything terribly radical about it. You saw the trailer. My feeling is that if Twitter is coming down on that kind of speech, that does make me somewhat pessimistic about what the future holds, because that's a pretty benign piece of work. And for them to come down on that, that's a concern.
So let me sneak in two questions. I know I have to wrap it up, but could advertisers have considered your tweet to be hate speech? And when do you expect the case to go to trial for a hearing?
I just can't see any world in which that film or any of my work is hate speech. I am truly of the belief that the people who work in corporations are no different than anybody else. I never attack the actual folks in corporations. My entire analysis and critique is based on the legal constitution of the corporation and the imperatives that it operates under and the failure of governments to regulate it. It's a political economic critique. It doesn't target people for hate or even really criticism. We have leading business people in the film. They're treated with fairness. Lord John Brown is in the film. John Coyne from Unilever Canada plays a substantial role. Klaus Schwab, the head of the World Economic Forum. They're all treated fairly. So no is the short answer. I don't think so.
And the case, do you think you'll go to trials?
Yeah,
fairly soon?
the courts in Ontario are currently very short-staffed, as is true in BC as well. And so the waiting time is long. So, I'm optimistically, I would say 8 to 12 months before this thing is actually heard.
We'll wrap it up there. There's still an opportunity. I think many of us will still be here afterwards. But I would like to thank the Allard School of Law and Alumni UBC for putting on this wonderful event. And I would like to thank all of you for joining us on this pretty good June evening to learn more about how town squares, like this one tonight, is threatening, under threat, welcoming, open, and closed. And how we all have so much to gain always if we just listen to one another. Thank you so much for being here tonight.